now in presentation mode.
Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. You would have heard all the disclaimers and caveats when you logged in. There is a recording in the conference that tells you what to do and what not to do. This is our first call of this year. Happy New Year to everyone. As usual, I will begin first with the frequently asked questions. I will then, once I answer a question, I will invite follow-up questions. After that, we will deal with the non-frequently asked questions, and if time permits, we will deal with follow-up questions. Going forward, I have told the team to stop taking questions after 14 or 15 questions because that gives us a little bit more time to talk, and it might even give us 5-10 minutes to talk at the end with new questions if we can deal with them. That said, let's start first with the first question that I have marked as frequently asked is, how do you port a priority date? Okay guys, in the middle of this conversation, if for some reason you can't hear me or something goes wrong, just call our office main line and tell them that you can't hear me. That number is 202-909-1110 and dial 0 after that, 202-909-1110. We have a couple of different phone numbers coming through the same lines. Okay, that said, the first question was, how do we port a priority date? So you've got an I-140 approval through any employer, and you are getting another green card processed either through the same employer or some different employer, and you want to carry forward the priority date. I've dealt with this issue several times before, but I'll repeat it. It's still the same process. The idea is, once the I-140 is approved, the priority date immediately becomes your property even if the I-140 is revoked. This law came into effect on January 17th, 2017. So that date is yours, whether or not it is reflected in a follow-up I-140 approval. So once you've got it approved, it's your property. You don't really need to do anything about it. USCIS should be giving you that date automatically. You shouldn't have to do any other process for it. They run regular screening or scans of their system, and they assign to you the earliest priority date to which you are eligible. That's the way it normally works. Suchit wants to know, I had an approved I-140 from employer A under EB3. This was the priority date 2012. Then employer B filed I-140 under EB2, got an approval, but the porting was requested but not given. That's not a problem. If you were to file a 485, you could take a copy of the old approval and the new approval and file them together, and that should be okay. So don't worry about it. This is not a big deal. *5 if you have a follow-up question, folks. Press *5 if you have a follow-up question. Okay, let's go on to the next frequently asked question. Let me just double check one more time that you guys can hear me okay. Let's see.
The conference is now in conversation mode.
Just confirming you can hear me all right, right? Folks?
Yes.
Excellent. Thank you so much. Okay.
The conference is now in presentation mode.
Now, here is another problem that we encounter sometimes, which is criminal arrests or convictions in immigration cases. How do you deal with them? Most commonly, there are violations, let's say for driving, reckless driving, or something like that. In this case, we have a misdemeanor case, and that was expunged. Normally, misdemeanors are treated as automatically forgivable offenses if it's only one misdemeanor, called petty offense exception. It's a complicated area of the law. Don't make any assumptions. Talk to your lawyers. But I am dealing right now with a more basic set of issues. When you are confronted with a conviction, how do you deal with it? First of all, expungement does not mean anything under immigration law. If you have been convicted, you are required to state so. Every form which asks you, have you ever been arrested, convicted, etc., you have to say yes, even if your record was expunged. For immigration purposes, expungement has zero effect. The only thing that helps you if your case is reopened after a decision against you and then the case is nullified. Different states have different names for this process. There is some states call it a writ of audita querela. Some states call it vacatur. So different names are given to this process where your conviction is reopened and overturned. Other than that, expungement has no meaning. Question is, I've got this in the background, I haven't brought this up earlier. Do I have to discuss it with my company attorney at the 485 stage? And the answer is no. What you can and what you should do is get yourself a private lawyer. Tell the employer you prefer to have your own lawyer for the 485 proceedings. And the 485 is your application. It isn't the application of the employer. So you should be able to get your own lawyer and get the 485 process done yourself. As to what documents should be submitted, etc., normally we submit just a certified copy of the court proceedings or the adjudication, the final adjudication. That's all we need. Nevertheless, I don't want you to make any assumptions. Talk with your lawyers, the lawyers that you hire privately. Star 5 if you have a follow-up question. Star 5. Okay. Let's go on to the next frequently asked question. This is from Chanel. The problem is the 240 days of extension are expiring. When you have an H-1B extension filed, you've got 240 days to continue working. Once that's expiring, what do I do? Well, you can stay in the United States. You just can't work. So while your H-1B, timely filed H-1B extension is pending, you are not illegal. Even after 240 days. You don't have work authorization, but you're not illegal. And by the way, you can also ask for an expedite at that point of time. I think it's a good ground for expedite. May not get it, but at least it's worth trying. Even though premium processing is not available, expedited processing is still available. If you are losing financially, employer is losing financially or humanitarian reasons, for example, you're putting kids through school, you need your paycheck, or you have to make your mortgage payments, at least try it. You might be able to expedite the case. Second question is, I have an approved I-140. Can I go back to India and apply for H-1 extension from there? Well, you actually don't have to do anything. If you leave and go to India, green card can go on, no problem with that. The only thing is your H-1 extension will be approved and you would have to go to the consulate to get visa stamping and come back. So that's not a problem either. In other words, you don't have to reapply for the extension. The pending case would work. The only thing is, since you left while the case was pending, you would be required to get a visa stamping and come back again with the same case that's pending. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go on to the next question. And this is a very frequently asked question these days. Downgrading a case from EB2 to EB3. And I think further down there's a follow-up question on that also. So I'll combine both of them in one. Let me begin with this one first. Been with my current employer since 2008. Well, actually, before I do this, let me give you the groundwork on how you should do this. First of all, when you have an EB2 case approved, you can use a copy of the same perm, and there's no 180-day deadline on that, as is on the original perm. You can take a copy of the perm and file another I-140 requesting EB3 classification. It's sort of like this. If you have a ticket for first class travel in the plane and there's room in the economy class, you can always go down to economy class. I don't think the airline would have any objection. In the same way, using EB2 perm to get EB3 is not objectionable to the government. They should have no problem with that. And it also doesn't mean that you are accepting a lower job. It is not a lower job. It's the same job. Only thing is, technically you have asked for a lower classification, even though you are entitled to a higher one. So I don't see any problem with that. Let's go through the questions. Can my employer file me under EB3 concurrently without affecting my existing EB2? Yes. Your EB2 does not get affected. You can file EB3 I-140. You have to file another I-140. EB3 I-140, and I believe you can file a 485 also if your dates are current. This was a little iffy, but there is an older set of question answers from the government where they have said that you can file concurrently. Nothing has changed. We don't know of any change in the policy. It's certainly worth a shot. What is the procedure? Do I have to file my labor and I-140 once again? Just the I-140. How long will it take? It takes whatever time it takes. You cannot do it premium usually. For premium, government needs the original PERM application and you don't have it. That's already in the hands of the government. Very rarely they will allow you to premium a case if they already have a copy of your PERM application, the original PERM application. Okay. So I don't see any disadvantages in this because both cases are surviving. Tomorrow, if the EB2 speeds up, you can always file the EB2 on top of the pending 485 and say, look, I filed with the EB3 I-140, but I would rather use the EB2 I-140. That's fine too. Just to carry on to this in the same thing about downgrading, Road Train 64 says, oh, I think it's the same individual. Yeah. You're not being demoted, sir. That's incorrect information. You're not being demoted. I don't see any problem with this at all. And if your lawyers are advising you that this is a demotion, talk with somebody else. This is bad information in my opinion. *5 if you have a follow-up question on this. *5. Okay. No questions. So when I say *5, you press *5 on your phone and I can see your hand go up on the dashboard. Okay, now let's go on to the next frequently asked question. Let me make sure I got that. Right. So these were all the frequently asked questions. Now let's go over the regular questions. First one is from Arpit Seth. The question is, how do we count H-1B time? So first of all, let's say your H-1B got approved on April 1st. But you entered the United States. You were outside the US. You entered the United States on June 1st. Your H-1B time begins to run from the date you entered the USA on H-1B. Those 2 months that you were not here, they can be recaptured the next time you ask for an extension. Your extension can never be more than 3 years, but if you have any time less than 3 years, captured time can be added. If it is not captured the first time around, you can capture it subsequently. Secondly, any time you have been physically outside the USA, that time can also be recaptured. Thirdly, this is the part which is a little bit difficult to answer, but I think I'm right. So let's say your H1 was expiring June 1st. You filed an extension May 1st, so timely filed extension. Your case took 8 months to process or 9 months to process. Let's say it came through in December. Between June and December, when your I-94 expired, I don't think the June and December period is H-1B. So it is not considered to be H-1B, at least in my opinion. I'm not aware of any policy decision that says it is otherwise. So time begins when you enter USA. Time for any time outside USA can be recaptured, and time in between expiration of the previous H1 and the second H1 where you have a limbo status should not be a problem. It should not be H1B. *5 if you have a follow-up question on this. *5. Okay. Let's look at the next regular question. This is from Vijak. Working as a dentist for an employer A, they filed for PERM I-140 EB2 from another office B in 2010. Both the offices were sold to another company in 2012. FEIN did not change. 2 years later, the FEIN for my sponsoring dental office changed in 2014. So is this a successor in interest situation? Successor in interest situation is not determined merely by a change in federal employer identification number. There is more to it. So whether or not this can be considered to be a successor in interest situation should be determined by your lawyer. They should look at the nature of the transaction. So for instance, if a third company came and bought over either all the assets or both the assets and the liabilities or the stock of the company, chances are it will be a successor in interest situation. It isn't just about FEIN. Okay, so have your lawyers assess this. You can definitely do a successor in interest. Can you also downgrade to EB3? I don't see why not. I think you can. Can you file I-485 concurrently? Let me think about this. Successor in interest and 485 concurrently. My guess is yes, but have your lawyers double check on that. I'm not 100% sure whether you have to first get a successor in interest approval and then file 485, but I think it can be done concurrently. Star 5 if you have a follow-up question. Okay. Edita 930 says, I want to know if my husband can transfer to me his petition for my son. I'm assuming you're talking about a family-based case or even an employment-based case. You cannot transfer petitions like this. Can I petition my son again through me? And please don't put your receipt numbers. You had your receipt number, so I deleted that. That's private information. Don't put it out publicly. I'm not sure what you're asking me, ma'am. I don't know the kind of case. I don't know whether it's employment-based, family-based, but generically speaking, you can always apply for your children if you are a green card holder, US citizen. If it's an employment-based case and you are the primary, your child under 21 or who's covered by CSPA, Child Status Protection Act, they can be added anytime. But you cannot transfer petitions from one beneficiary to another. Star 5 if you have a follow-up question. You actually have given me very sketchy information, so I'm doing the best I can with that. Okay. S visa, I don't know anything about S visa, Nikki. We don't do S visas, so my apologies. Our practice, at least my practice in this firm, is very sharply focused on complex immigration cases, immigration litigation, and employment-based immigration, business-based immigration. Family-based immigration also, but normally we tell people to hire us only if the case is complex or if you just don't have the time and you would rather have a lawyer handle it. Most family-based cases tend to be straightforward. So I don't do S visas, even U visas hardly ever, although we might start taking them. U visas are very beneficial in some ways. I'm not sure how S visas work. Krishna 3. Currently I'm working on H1B extension receipt. I see. H1B extension receipt. Okay. So the 240 days, I guess. I-140 is approved. Yes. 240 days are completing Feb 20th. Extension was filed in April. Same employer, same client. I-94 expired. Receipt transfer from California to Nebraska. Received RFE. Responded. Am I allowed to convert? Well, you can convert to premium if your case is extension without change. So normally when we have an extension without change, we file with Nebraska and it appears that your case is already in Nebraska. It doesn't hurt to check. If it is an extension without change, call the service center, ask them, can you premium your case before February? In February, we expect USCIS to reinstate premium processing for all cases. So to answer your question, am I allowed to convert premium? If it's an extension without change, it's certainly worth trying. Star 5 if you have a follow-up question. Okay, there is a follow-up question. Let's see. This is from California. Yeah, California, go ahead, I can hear you.
Rajiv, so extension without change means, can you explain me what is without change?
Right. I'll explain that to you. So extension without change means the job description is the same, or very, very similar, very close. Job location is the same. Salary, etc. is similar. It doesn't have to be exactly the same. So extension without change is filed. There's a particular box on the form I-129, which we check when we file extension without change. Your lawyers can tell you whether your case was filed as an extension without change. Okay.
So yeah, I will check. And the other thing is, if we file extension with amendment, can we work even 240 days is crossed?
Yes. If it's an extension, you can continue working whether it is with change or without change.
No. If it is so extension also, even if it is extension after 240 days, we cannot work, right?
After 240 days you cannot, but up to 240 you can.
Yes. No, I'm asking extension with amendment. If amendment plus extension filed together, can we work after 240 days?
Not after 240 days. See, amendment is still with the same employer, right?
Yes, same employer.
Same employer. There's a difference in the laws. I have looked at this and I kind of forgot exactly what the difference is. But from what I remember, if you change employers and you file a transfer, you can continue working as long as the case is pending. That's under AC 21, American Competitiveness in the 21st Century Act. That's an AC 21 portability. As I recall, that's the difference between the 240-day extension, which is 240-day permission, which is given for the same employer, and transfer of employers, where you can continue working as long as the case is pending. Okay?
Okay.
You understood? No? Okay.
I mean, actually,
Yeah.
60% I understood.
I had a feeling you have not understood. Let me repeat. Okay. So one is an extension. Extension means you're working for the same employer, right?
Yes.
You're asking for more time on your H1B, right?
Yes.
Extension can be combined with an amendment. That means your job has changed, job location has changed, salary has changed, something has changed, right?
Yes.
All extensions are covered by the 240-day period.
Yes.
But when you go from employer X to employer Y, you have a different situation. It's a transfer case. In transfer cases, you can continue working as long as the case is pending.
Okay.
Got it?
But the same employer extension plus amendment, can we work after 240 days? Same employer.
The answer is no. All extensions 240. All transfers,
Okay.
no limit. Yep. Okay?
Okay. Yes. Got it now.
All
Yes.
right.
Thank you.
You're welcome. The law can be unnecessarily complicated sometimes, but that's how it is. Okay, so we covered Krishna's questions. Let's go on to, I guess this is Satish Kumar. We have people from North Carolina, Pennsylvania, Colorado, New Jersey, California, Colorado, Illinois, Michigan. So it's pretty much all over the country. I think most of you have new questions. That's why I'm not hearing any follow-ups. So I think we have enough time today. It's only 23 minutes into the call. We'll have at least half an hour to go deal with new questions. So I'll try to do my best. So this one is from Satish Kumar. I was on L1B for 5 years. H1B till now. Green card EB2 is in process. 2014, when my visa was maxing out, you applied for F1. F1 was denied. From June 2014 to September 2014, you were attending school. H1B was approved on September 2014. So, because of the I-140 approval, okay. Then you went and got your visa stamping without any problem. I don't see any issue with this. I don't see any issue with this because you went to school in those days. If I remember correctly, the regulations used to allow you to go to school while your change of status was pending. So you did not do anything illegal, plus you already got a visa. I don't see any problem. As there are too many rejections in stamping these days, I want to know what is the probability of getting my visa stamped. Look, I don't know what your H1B case is, but this background does not give me any room for doubt or any cause for concern. I think this background is straight and simple. I don't see any out of status period. The time that you were maxing out on visa, you applied for F1, and I'm assuming you applied in a timely manner. So I'm not sure what your concern is. Star 5 if you're on the phone. Star 5. Let's talk about this. Okay, you're here. Let's see. This is New Jersey. Yes, New Jersey. Go ahead, please.
my attorney. He said currently there is a 221G and there are a lot of administrative processes going on.
Oh, that's a different issue, sir. That's a different issue. That has nothing to do with your case. In general, visa stamping has become exceedingly difficult. Government is trying to deny, under Trump administration, they are trying to deny as many cases as they can. Some of them are ridiculously pretextual. They are more an excuse than a good adjudication. So whenever you apply for a visa stamping, it isn't because of this background. It is just because they are trying to make things difficult. We can try to assess in 3 seconds exactly where you stand. Are you working in-house or at a client site?
I'm at client side. I have employer, vendor, and client.
Okay. Do you have access to the client side? Can you get end client letters, etc., and verifications? Because the consulate sometimes send an email to the end client.
Yeah, they agreed for the client letter, yes.
Okay. If you were stuck in India, let's say for 2, 3, 4 months, 5 months, will the client still keep the project for you? Now remember, there is no, if your job doesn't involve any export restricted technologies like encryption, etc., you can work from India without any problem. So even while you're in India, you can continue working. So if the answer is yes, they can wait for me, I don't see any problem, or at least I don't see any obvious problem. I still don't know all of your case. If you can avoid it, avoid it. But if you must go, then I would probably go to Canada first. Okay?
So getting stamped in Canada is easier.
I think they're a little bit more reasonable, generally speaking, but of course it varies from officer to officer. But I think generically they are more reasonable. Okay?
Okay. Yeah.
Good luck, sir.
Thank you.
You're welcome. Okay, so Ashneet says kid is aging out in April, applied for H4 to F1. I don't know, ma'am, how long it takes. I have no clue. I can't tell you. You can call the USCIS customer service and find out. I also applied for EB2 to EB3 transfer. If the priority date becomes current, yeah, I think you should try filing a 485. In a pending case also, if the priority date becomes current, I think it's worth a shot and I think it should go through. So while your downgrade is still pending, using the receipt number of the downgrade, you could file the 485. If the kid ages out and the EB3 I-140 is still in process, will the processing time after the kid turned 21 also be deducted from his age? I do not know, ma'am. I don't think there is a good answer to this question. CSPA allows us to deduct from a child's age all the time during which the I-140 was pending. But what if it is a repeat I-140? I would want to very aggressively say that the law allows me to deduct the age of my child while the second I-140 was pending. I would argue for that. I don't know if I would succeed. *5 if you have a follow-up question. *5. For some reason, the number of questions was increased. I guess a couple of questions were added later on. So I'm still trying to go through it real quickly and leave time for new questions. Ashneet, we dealt with. Syed Muhammad. Employer filed I-120 H1B. RFE asked for itinerary. My employer is a direct vendor to a client. They sent the RFE response with an MSA, task list, timesheet, copy of billable time, supporting docs, but they denied the case, saying the contract is effective for 2 years. And the LCA is 3 years. They question the decision. Where will be my duties? That's a ridiculous reason for denial. That's a ridiculous reason. I can't answer your question. The question that you're asking me is so broad, it is impossible to answer. What document should we send for appeal? Let your lawyers decide that. Will I be eligible for next time filing in case my appeal is in process? Look, you can always file an H1B for another project. Success rate of appeals is only about 2%, although it has gotten a little better because government has been denying cases too frequently. Time is about 6 months from what I remember. last time I checked. We have a couple of cases in the pipeline, H-1Bs. You can also consider, talk with your lawyers, filing directly a lawsuit against the government. It appears to me a very bad reason for denial. So some of these denials are almost illegal. When I look at them, it just doesn't make any sense. This is all the Trump effect trickling down. Basically, the guy in the White House who calls himself the president has decided that they are going to flirt with the law as much as they can. And they are. With the result, the number of lawsuits being filed against the government has increased tremendously. Star 5 if you have a follow-up question. So file the appeal. I don't see any harm in that. But remember, unlawful presence continues. Appeal does not toll your unlawful presence. You can always file a second case. One denial does not foreclose filing of a second case. Okay, so you're not here. Let me go on to the next question. Prasad, fourth year of H-1B, I-140 is approved under EB-1C. My client changed, but the employer is the same. They applied for H-1B petition amendment. Oh, so you were on H-1B, not on L-1A. Okay, but you got your EB-1C. If H-1B is denied, please help me with my questions. If I have to go back to India immediately, your green card can still go on. I heard of consular processing of green card at home country. Would this processing still hold good? Yes, of course. Your case can be converted to consular processing. What is AC 140? Attorney certified 140 is not acceptable to the best of my knowledge. Many years ago, this used to be allowed, that instead of filing certain number of forms, we could just send a certified copy from our own files. I don't think that works any longer. That saves you some time, but it's not the end of the world. Can I apply for an H-1B extension from my home country? Yes, you can. Would it be a cap exempt? Cap exempt. Because you had an H-1B approval, it was denied, it can be refiled. Planning to apply for Canadian permanent residence, does it impact my green card? It does not. Ultimately, USA should only be concerned with where you want to live permanently, not how many other countries PR you hold. So if they try to browbeat you or bully you, your lawyer should be able to get back in their face and back them down. Because any questioning about you having PR, permanent residence of more than one country is irrelevant. USA should only be concerned about whether or not you want to live in USA permanently. Okay? Star 5 if you have a follow-up question. Star 5. Okay. Now, this last question is about removal of condition on conditional resident status. I'm sorry, I don't know the answer to this question. There is a memorandum a year or two old. There is another group of people within our own office who deal with I-751s. I know that there's a memorandum out there. We just received, there was actually a gay couple who had gotten married and then they got divorced, and we got the 751 approved for her just a couple of weeks ago. So it can be done. I don't know what the procedure and the process is. Please talk with your lawyers. If you don't have one, make an appointment with a lawyer. They should review the law and update you about what needs to be done. It's not the end of the world. Okay, but I don't know the answers off the top of my head. This has gone through some change, this process. Star 5 if you have a follow-up question. Star 5. Okay, I've got about 20 minutes left to deal with new questions. Anybody has any question, press star 5. Anybody has any question, press star 5. So far I have only one person raising their hand. Wow, a lot of people just wanted to listen. Okay, 3 people raising their hands. The first person I will call upon is Emmy. Emmy, I don't know what Emmy is. Portland was it? I thought Oregon. Okay, area code 207. That would be, oh, there's 5 people who raised their hands. So the first person I'll call upon is ME, area code 207, then Colorado, then I will call upon New Jersey, then North Carolina, and then Pennsylvania. Okay, so let's begin with the first person, which is area code 207. Okay, sir or ma'am, go ahead please. Area code 207.
Hi, doctor.
Hello.
Hi, this is Priya here. Actually, Currently, I'm on OPT right now, and it ends on April 24th.
Okay.
So if I file my H1 on April 1st, I would not know my lottery results until May or June, right?
Right.
So what options do I have to still be able to work until I know my lottery results?
You can, absolutely no problem. You can get what is called gap extension. So you go to your school.
You mean F1 gap?
Right. Right. So basically you go to your school, they'll issue you a gap I-20. Okay?
Okay, but they need your documentation from my employer, right? Like proof of delivery to USCIS service centers or a waitlist letter. So they suggested me to speak to.
I don't exactly know what they will need, but one of the things you can do is, under the law, I believe the USCIS has to deposit the fee checks within 3 days of receiving them. So if you don't have a receipt, you'll have proof of delivery. Okay, use FedEx, you'll have proof of delivery. On top of that, your employer should be able to get the cancelled checks from their banks. Okay?
Okay.
Good luck.
So that is when my application is not picked, right? I didn't understand about the
Look,
concept.
before you are run through the lottery, right now they might change the system this year, but under the old system, before you are run through the lottery, they take your case in. You know what? I don't recall exactly how this works. They take your case in, but they don't deposit your fees. You can only have proof of delivery, right? So they don't.
And also, under the required documents, they have also listed the waitlisted letter, proof of waitlisted letter, and proof of delivery. These two are the.
They need all of these things. They need all of these things, just the proof of delivery.
They need waitlisted letter and proof of delivery, both of them.
There is no such thing as waitlisting letter. I guess you can get something from your lawyers, but there is nothing. USCIS never gives anything official like that. These people are crazy. If your DSO wants a proof of waiting letter, what the heck is that? Never heard of that.
Okay, then I might have to convince them and just provide.
No, just have your lawyers call them up. That's absolute nonsense. I've never heard of a proof of wait letter. What the heck is that? No such thing. Okay?
Okay, thank
Yeah.
you. And that's official work authorization, right? If I get I-20
Yeah, see, I've never had to look into this because we've never had a problem. That's why I'm a little confused why you should even have a problem. Maybe your DSO is not following the procedures. So just make sure that your DSO, the designated school official, is up on the procedures. Okay?
Okay, thank you very much.
You're welcome. Good luck.
Thank you.
Okay, now I'm going to Colorado. Colorado, go ahead. Oh, 1 second. Colorado, go ahead, please. Or did I screw
Hi,
this?
Raju. I'm Harika.
Yes, ma'am. How are you?
Well, I'm good. How are you?
I am well, thank you.
Well, I'm on OPT right now, and my H1B got selected in 2018.
Okay.
Lottery. And when it got selected, I was with one client, and
Hang on, ma'am. I didn't understand. When it got selected, then what happened?
when it got selected, I was with one client. Say, for example, the client name is
Your voice is not clear, ma'am. I can't hear you. Your voice is not clear. Can you get closer to the phone?
Can you hear me now?
Much better. Yes. Tell me. So I heard that you got selected. When you got selected, then what happened?
When I got selected, I was with client A.
Okay.
And later on, after a few months, I had to change my job, and now I'm with client B. And now I got a query with
Okay.
says,
Hang on.
to provide
Hang
documents.
on.
Sorry.
I need some information.
Yes.
Your employer is the same, just the end client has changed, right?
Yes, that's right.
Are the end clients in the same neighborhood within the 40-50 miles?
No, the first client is in New York, and the second client is not the quota.
Okay. Now, you are still on OPT, right?
Yes, I'm still on OPT.
Okay. So under OPT, you could change employers, no problem. And this is OPT, 1 year OPT, right? Not the OPT STEM extension.
The STEM extension. I'm on STEM extension.
That makes things a little bit more complicated. Nevertheless, what you should be doing is this. While the first H1B is pending, your employer should file an amendment. Okay? So listen to me very carefully.
Okay.
Have them file an H1B amendment to reflect the new employer. And in response to the RFE that has come for the first case, respond by saying that an amendment is being filed and note that she's still on OPT. Okay?
Okay.
And we had this issue come up last year. It worked out fine. We didn't have any problems.
Okay.
Okay? But to be even more secure, have your lawyer call and speak with the USCIS customer service. They usually are taken to, when they have a important legal question, they usually get an adjudications officer involved and they will get good information, or reasonable, as good as you can get from the USCIS. So do that. But I think this is manageable. Don't worry about it. Okay?
Okay. So now what can I do is I have to amend first and then have to respond to the RFD.
Right. What I do is I attach a copy of the amendment and say, here, Mr. RFE, this is no longer applicable. I still try to give information enough to show that the case was approvable when it was filed. It's still a requirement. It's complicated. I can't really do it in a 2-minute call. Your lawyer should know how to do this. They should be able to, they still have to demonstrate that the case was a good case when it was filed. It wasn't a pretextual case. Have them respond with that along with a copy of the amendment showing that since the client has changed, you're still on F1 OPT, you're allowed to change clients. You are filing an amendment also at the same time. And I think that's fine. Okay?
Okay.
Well, this call is being recorded, so you can always play this recording for your employer if you like. Okay?
Sure. Thank you so much.
You're welcome. Good luck, ma'am.
Thank you.
Okay, last 3 questions, guys, then no more. Let's go to, we've got New Jersey, North Carolina, and Pennsylvania. Let's go to New Jersey first. Okay, so how do I do it? This is how I do it. Okay, select. New Jersey, go ahead, please.
This is Satishs again. Regarding the same 220 administrative process. So, just wanted to understand, do they just validate my, as part of administrative process, if it goes through, do they just validate the current employment in the client location, or it goes further to check that person can be filled by the local hire?
I don't understand that question. Look, a visa that is given to you by the consulate is not holding you to a particular client or even a particular employer. So once you get the visa stamped for employer A and client AA, you've got the visa stamp. If you change the client to BB, the same visa is good. Or to CC, the same visa is good. Even if you change from employer A to employer B, the same visa which was given for employer A is good. Okay?
Okay, but my question is, when I'm thinking when I go for the stamping, if there is an administrative process, I think based on,
Right?
the administrator may come for the client location to verify the proper stuff, right?
Right.
So that verification, do they just verify the location and just
I'm sorry.
evaluate?
Yes, I misunderstood. Well, there are several kinds of verifications. If the consulate sends their investigators from the Kentucky Center to investigate, typically they will speak with your supervisor. They'll ask about the job description, job location, who supervises you, etc. Okay? Good luck, sir. Good luck. You're welcome. Okay, last two questions. Let's go to North Carolina. North Carolina, I can hear you. Please go ahead.
Hey Rajiv, how you doing?
Hello, sir. How are you?
Good, good. Sorry, I might have missed it, but I had the conditional green card question.
Okay.
And I didn't get the context of.
And the answer is I do not know the answer to your question off the top of my head. I have to go look at the memorandum, which was, I think, published by the USCIS a year or two ago. You can go look at their website, or better still, go to a lawyer, get them to review the memorandum and give you the answer. I don't know the answer off the top of my head. Okay?
Okay, thanks.
Good luck. Sorry about that. Okay, so yeah, just to make one thing clear, I know a lot about immigration law, but I don't know everything. Nobody does. So let's just go to the last question is from Pennsylvania. Pennsylvania, go ahead, please.
Hello, hi, Ben, Rajiv.
Yes, sir.
I just think that I'm on B1, B2 visa here,
Mhm.
and my parents are green card holder here. Is
Okay.
there any way to get to stay longer here?
No, sir.
To file and
No, sir. The way it works is
Yep.
your B1, B2 is given to you for temporary visit.
yeah,
If there is a reason, a good reason to extend it, you can extend it, but don't do it yourself. Get yourself a lawyer, have them discuss your case with you. There are implications of fraud, misrepresentation, etc. Also, if you are the son of a green card holder, it could take many years for the green card to come through. You cannot continue to stay here while that green card is pending. The only people who are allowed to stay here are those whose priority dates are current. Yours is not. So therefore, you can apply for a green card, but you can't stay in the USA based upon that. You have to look at other options.
okay. So I checked on the website. There is a petition filing from by my parents, like I-130 form. They petition for me.
Mhm.
Yeah, I think. And then other thing is that the on the AOS adjustment of age.
Yeah, hang on. Sir, I understand.
What's that?
I've been doing it for about 30 years. So, yeah, I understand how it works. But the thing is, this kind of information is actually available on the USCIS website. You don't need me to tell you that. But I'll just give it to you real quickly. I-130 is simply the form that the government adjudicates and says you're entitled to get your green card. That's not a green card. Then
Yeah, I know.
you wait
Yeah,
until your priority date becomes current. You cannot file 485. You cannot stay in the USA. Once the priority date becomes current, if you are legally in the United States, for example, on an H-1B visa, you can then file for adjustment of status, which is 485.
Okay.
But if you're outside USA, hang on. If you're outside USA, after the I-130 approval is done, your file is sent to the consulate through different processes. It gets to the consulate and you are close to your priority date becoming current. You'll then be asked to take medical, etc., and appear for an interview at the consulate.
Okay.
Okay.
So, could you please tell me how many years it takes?
I don't know. It depends upon the country of birth and the classification. Go to
Yes.
Visa Bulletin. Go to Visa Bulletin and look up the waiting times.
One thing more, can I travel around like after paying the my parents are going to fill out my petition like in next week? Can I travel around
Within USA? Within USA? Absolutely. Why not?
I can travel like I have 10 years in visa. I can
No,
travel
no.
after
You
1 year
you don't.
every time.
You don't. Once you file a green card, CBP at the airport, if they find out you have a green card pending, they can tell you turn around and go back to your home country. You can't come in. They can do that. Filing a green card
Yes.
can negate your tourist entries. So tourist visa doesn't mean that you are guaranteed entry. Okay?
Okay.
In
So we
future.
can travel like that.
In future.
Exactly.
In future. So you might have to keep that in mind. Okay?
Oh, okay. So
Good luck, sir.
all right. Thank you.
Oh, you're welcome.
Thank you.
Okay, there are 4 or 5 people who have their hands up again. Guys, I'm sorry. As I had said that if you don't have your hands up the first time around, I won't be able to deal with it. I've got to get back to work. But we can talk again in 2 more weeks. As always, thank you so much for being here. I love talking with you. And as you know, we do it every 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.